What does it mean for a property to be fit or unfit for human habitation, and how do we determine a property's fitness? Now, this isn't defined in the legislation, and there's no case law yet that specifically refers to the Home's Fitness for Human Habitation Act 2018. However, we can get an idea from cases about other legislation that refers to fitness of rented properties. And these cases give us an idea not only of the kinds of things that might make a property unfit, as that is clearly set out in the legislation, but also how bad the condition of the property has to be. So let's turn first to infestations. In Smith and Marrable, which is a case from 1843, evidence was given that all the beds in the house except one were infested with bugs, and one witness stated that on the first night of occupying the house he caught 34 bugs in and about his bed, and on the second night not quite so many. 2 other witnesses agreed that there was a severe infestation, which meant that they could not sleep, they felt insects crawling over them in the bed, and there was a strong smell of bugs. It was found there that the house was not fit for occupation. Now, before the Fitness Act, it would be very difficult to bring an action against a landlord for an infestation of bed bugs, save for in the specific situation of furnished accommodation at the start of the tenancy. Unless the infestation is the tenant's fault, an infestation of bugs would be the landlord's responsibility under the Fitness Act. Now, going back to 1843, in Smith and Marrable, the jury, as they then had in civil claims, had to decide whether the number of bed bugs was more than a long and hot summer would be likely to produce. And it was taken as a given then that every home may have some bed bugs in summer, which is thankfully no longer the case. So now a less severe infestation than that experienced by the Marrable family could well render a property unfit. Let's turn to lack of ventilation. So a case from 1941, Summers and Salford Corporation, a broken sash cord to a window in a bedroom meant that meaning that the window could not be opened, rendered a property unfit for human habitation. The broken sash window fell on the tenant's hand, injuring it, and the window was the only window in the room, and the room was small. Lord Justice Luxmore's decision is worth quoting from extensively, as it deals with the important distinction between being fit for habitation and uninhabitable. And he says, "I agree that, at first blush, it would seem extravagant to say a house is not fit for human habitation, because the cords supporting one of the sashes of one of the windows in it are broken, or in such a state that they are likely to break at any moment. This may well be due to the tendency to connect the phrase fit or unfit for human habitation with a demolition order. The duty imposed on the landlord by the Act is to keep the house, in all respects, reasonably fit for human habitation, and that one of the essential matters by which its fitness for human habitation is to be ascertained is the existence or lack of ventilation. The usual method for providing ventilation for a room in a dwelling house is by a window or windows, which are so constructed as to open or shut without danger to the person open or shutting it or them. If a room, especially a bedroom, has only one window, and that window cannot be opened or shut without danger to the person seeking to perform that operation, that room may, in my opinion, be said to be not fit for human habitation," said Lord Justice Luxmore. Another case, Morgan and Liverpool Corporation, also dealt with a broken cord in a sash window. A judge in that case concluded that a broken sash cord here rendered the property unfit for human habitation, concluding that whilst a broken cord in a large house with many windows would not make the property unfit, the only window in a small house with only 2 bedrooms may render a property unfit if it cannot be opened or closed. And now let's move on to thinking about infectious disease. There is a wealth of case law on infectious disease, and until COVID times we would have noted this only as a historical interesting point, but sadly it may once again be relevant. So let's go back to 1884 to Bird and Lord Greville. Here, a house was unfit for human habitation where a child with measles had left the house 10 days previously. Steps had been taken to disinfect the property, but they were found to be insufficient. And likewise in Collins and Hopkins from 1923, the house was unfit because the previous resident had been recently suffering from pulmonary tuberculosis. He had left the house 6 weeks before the tenants took occupation, and the test applied then was there an actual and appreciable risk to the tenant, his family or household by entering and occupying the house in which the infectious disorder had occurred? So whether a property could be unfit for habitation because a previous occupant had been suffering from coronavirus would rely on medical evidence on how long the virus could last on surfaces and the steps taken to clean the property, but this could make a property unfit. The next issue to consider is inadequate security. In Bowl and Another and Huntsfield Limited, so this from 2009, a home was not fit for human habitation due to inadequate foundations, meaning that garage doors did not lock and there was no security. It was found that the obvious purpose of a dwelling is for it to be occupied and inhabited safely and without inconvenience. If it does not meet this purpose, it is unfit. So, how to consider whether a property is unfit for human habitation. In Rendlesham Estates and Others and Barr from 2015, this summarised the recent case law on fitness for habitation and concluded that the specific facts in each case should be considered. The property should be considered as a whole rather than defect by defect. So many more minor defects may have a cumulative effect. And for a dwelling to be fit for habitation, it must be capable of occupation for a reasonable time without risk to the health or safety of the occupants. Where a dwelling is or is part of a newly constructed building, what is a reasonable time will be a question of fact, and it must be capable of occupation for a reasonable time without undue inconvenience or discomfort to the occupants. The issues in this case causing properties to be unfit for habitation included damp, condensation, mould, leaks, and a lift that broke down with monotonous regularity. So, in conclusion, unfit for human habitation does not mean uninhabitable. A minor defect will not in itself make a property unfit, but if it causes a risk to health or safety or undue inconvenience, then a property might be unfit for human habitation. The purpose of the Homes Fitness for Human Habitation Act 2018 is to improve living standards, not to close or prohibit properties from being occupied. This should be taken into account when deciding whether a property is unfit for human habitation. If you have any questions about housing and property law, feel free to ask them in the comments and we'll do our best to answer them in as much detail as possible. If you're looking for more legal information, please subscribe to the Anthony Gold YouTube channel to make sure you receive updates from some of the best lawyers in the UK. If you need professional help with a case, please go to our website at anthonygold.co.uk or call us on 0207 940 4060.